Welcome everyone to this, the last day of the conference. Now I know that some of you are tired after the wine tasting last night, but I do think we have a real treat for you here. A panel on immunities. And I say that with a sense of irony because normally this is not exactly a sexy topic. But I do think that given the circumstances, it is an exceptionally important topic to address. And I know that a lot of you are looking forward to this panel. So, of course, the South African courts have now decided that, twice actually, that the decision not to arrest Omar al-Bashir in June 2015 was unlawful. And that is the reason why everybody is talking about immunities. This panel will not just focus on that decision. We will talk about broader issues. So the issue of immunity for heads of state under international law more broadly, and the future also of international criminal justice. So keep that in mind. It will be a slightly broader conversation. And really to address these issues, we have an incredible panel, I think, a really wonderful lineup of speakers. First, on my extreme right, we have Dapo Akande, Professor of Public International Law at the University of Oxford. Then we'll have Tladi, Professor of International Law, University of Pretoria, also Special Advisor to the Minister of International Relations and Cooperation in South Africa, and also a member of the UN International Law Commission. Then we'll have Max du Plessis, Associate Professor at the University of KwaZulu-Natal, and also an advocate of the High Court of South Africa. And last but not least, Christopher Gevers, lecturer at the School of Law at the University of KwaZulu-Natal. So without further ado, I'll just turn it over to Dapo Akande.
Thank you very much, Patrick, and let me start by thanking Bettina and everyone who's worked really hard in organizing what's been a great event. The question of immunities of heads of states is one question that keeps popping up every now and again in relation to the ICC. Somebody asked me yesterday evening whether one could have foreseen that this would become such a big issue with the ICC. And I said no, because in fact, in 1995, somebody asked me when I was just starting out as a graduate student, asked me to write something on immunities of heads of states under international law. And I thought, no, this isn't really going to be a big deal for the future. I don't think this is something that I want to write upon. But thankfully, I took his advice later on, and I did write something later on. So I want to focus on the immunities of heads of states in cases where the head of state is wanted for prosecution by the ICC. So I'm really going to focus on those cases where the ICC has issued an arrest warrant or is considering issuing an arrest warrant for a head of state. And what I want to do is just to set out the legal framework. As Patrick has said, I won't focus specifically on the Bashir case, but I'll mention some things in relation to Bashir. My goal really is just to set out what is the legal framework? How should we actually address these questions? And the first thing that I want to say is that when we consider whether a head of state is immune from ICC jurisdiction, there are really two questions that this seemingly one question raises, and it's important to divide up this question into two. So the first question is whether a head of state is immune in proceedings at the ICC itself. So is the head of state immune from the jurisdiction of the court itself? Or to put that question differently, can the court itself exercise jurisdiction over a head of state? So that's question number one. Question number two, which is related but is a different question, is whether a foreign head of state is immune from the national criminal jurisdiction of a state that has been asked to cooperate with the ICC. So those are the two scenarios. So is the foreign head of state immune from the national jurisdiction of a state that has been asked to cooperate with the ICC? Now it's important to note, and I put this just in parenthesis, that the question or the position that applies with respect to ICC proceedings or other international tribunals is different from the question of immunity in purely national proceedings that are unconnected with the ICC. So with regard to cases where one state seeks to exercise criminal jurisdiction over the head of another state, and where this is unconnected with ICC proceedings, the answer is fairly simple. International law accords immunity ratione personae, or if you like, it's a personal immunity to heads of states, heads of government, and foreign ministers from the national criminal jurisdiction of other states, even when they are accused of committing international crimes. And that position was established by the International Court of Justice in the arrest warrant case. So we put that position to one side where there are no ICC-related proceedings. So now to return to the two questions regarding the ICC. Immunity from the jurisdiction of the court, immunity from a national jurisdiction that's asked to cooperate with the court. The other thing to introduce at this stage is that with respect to each of those questions, there is an important variable, or at least there's a variable which is arguably important. Okay, so for each of those questions, there's one variable which could be important, and this is the head of state that we're talking about the head of a state that is a party to the Rome Statute, or the head of a state that is not a party to the Rome Statute? And that question arises at both levels, whether we're talking about the jurisdiction of the court itself, you can ask that question, and whether we're talking about the jurisdiction of national authorities that are being asked to cooperate with the court, you can ask those questions. Now, the starting position obviously is the ICC statute. What does the ICC statute say about these questions? There are two provisions in the ICC statute which I'm sure you're all familiar with. Article 27, which in summary says that immunities under international law shall not bar the court from exercising jurisdiction, in summary. And then Article 98, which says that the court shall not proceed with a request for an arrest or surrender where the requested state would be violating immunities. Now, one way of looking at those proceedings is to say that Article 27 addresses the first question I talked about, that is the position before the court itself, and that Article 98 addresses the second question, which is what is the position with national authorities who are being asked to cooperate with the court. That's one possible way of looking at it, though as you will see, I don't think that that division actually works so strictly. So let me start with the first question. What's the position with regard to immunities before the court itself? This is fairly simple as well because of Article 27. Immunities shall not bar the jurisdiction of the court. That's quite clearly says that the court will have jurisdiction even when the accused person is a head of state or someone who otherwise benefits from immunities under international law. Then we have this variable that I spoke about. What if the accused person is a national of a non-party, so a national of a state that is not a party to the Rome Statute? One argument that has been made, and this is the position that was taken by one ICC pretrial chamber, one argument that has been made is that under customary international law, heads of states do not have immunity at all before international tribunals. And if that is correct, that would mean, if this is correct, that under customary international law, once you're before an international tribunal, there is no immunity, it would mean that it then makes no difference whether you are a head of a state party or a head of a state that's not a party. The ICC pretrial chambers seem themselves to have backed away from that position in later decisions relating to Bashir. And I myself do not take this view. I don't take the view that there is a customary law position that once we're talking about an international tribunal, that therefore means that there is no immunity even for non-parties. I think it's clear that for parties to the Rome Statute, they have agreed that there is no immunity under Article 27. And then we can have a discussion, which I will turn to in a minute. What about a head of a state of a non-party in cases where the Security Council has referred a case to the ICC? My view is that in that case, there is also no immunity because that state is in effect in a position as if it was a party. The position, as I would summarize it, would be that in cases where there's an international instrument that is binding on the state, which subjects that state to the jurisdiction of the International Tribunal, then there is no immunity for the head of state, whether that's from the Rome Statute itself or whether that's by way of Security Council resolution. But the bigger question really has been the second question. That has been the question that has exercised our minds, principally in the case of Bashir. When a national, either national authorities or a national court are asked to cooperate with the ICC by arresting and surrendering a head of state, does that head of state have immunity at the national level from the jurisdiction of the other national entity that is being asked to arrest? That has really been the bigger question. That was the question that was faced here in South Africa and in all the other countries that President Bashir has traveled to. The reason why this question is complicated is because of that provision in the Rome Statute that I referred to, Article 98. Because Article 98 says that the court shall not proceed with a request for arrest when a national entity is asked, would be violating immunities under international law. So the question that then arises is, can one say that the Rome Statute has removed immunity not just at the international level, in cases of a person wanted by the ICC, but has it also removed immunity at the national level? Now, to be fair, the statute is not crystal clear on this point. The statute is not crystal clear on this point. But my view is that the best interpretation of Article 27 is that the Rome Statute has removed immunity not just at the international level, but also at the national level, at least for parties to the Rome Statute. Now, how does one reach that conclusion? How does one reach the conclusion that Article 27 has removed immunity also at the national level, given that Article 27 just says immunity shall not bar the court from exercising jurisdiction? One point that I would make is that this interpretation is the interpretation that many states parties to the Rome Statute have taken, and they have included this interpretation in their domestic law implementing the obligations. So when we look at the Vienna Convention on the Law of Treaties and we talk about the rules for treaty interpretation, we can look at subsequent practice which establishes the agreement of the parties. There are a number of domestic statutes implementing the ICC that take this view that the effect of the Rome Statute is to remove immunity also at the national level, at least for parties to the Rome Statute. And the reason that I think that this is correct, actually in reasoning which is fairly similar actually to the reasoning of the South African Supreme Court of Appeal in their decision last week, is that Article 27 would in effect be redundant if the immunity at the national level for parties was also not removed. It would in effect be redundant. Why is that so? That's so because the ICC does not have its own enforcement arm. The ICC can only exercise jurisdiction over an individual in cases where that individual is either arrested or surrendered by a state or they surrender themselves. And when Article 27 says that immunity shall not bar the jurisdiction of the court, international law immunity shall not bar the jurisdiction of the court, it clearly isn't addressing itself to the national state of the individual, because there are no international law immunities before your own state. The only possible situation that is left is a situation where you are being asked, where the state that's being asked to arrest and surrender is a foreign state. And so in circumstances where that head of state continues to possess immunity, the head of state would never get before the court. So immunity would bar the exercise of the jurisdiction of the court unless we took that immunity as also not existing at the national level. But what then of non-parties? That's the difficult situation. What then of heads of states of non-parties to the Rome Statute? And in particular, what then of the position of non-parties to the Rome Statute, where it is the Security Council that has referred the case to the ICC? That's the difficult question that we have had with respect to Bashir. And I think that one can make the argument, and this is the position that has been adopted by later ICC pretrial chambers, that in cases where you have a Security Council referral, that the immunity that would otherwise accrue to the head of state of a non-party has been removed/waived. What's the argument for adopting that position, that in the case of a Security Council referral, there's no immunity? Now, there are two possible arguments here. And the ICC pretrial chambers take one, and I probably take a slightly different one. One argument is to say that because the Security Council requires the state to cooperate, so the resolution with respect to Sudan requires Sudan to cooperate, one argument is to say that that obligation to cooperate in effect requires Sudan to waive the immunity, and that is what does the job. I actually don't take that view. I don't think it's the cooperation obligation in itself that removes the immunity. My view is that the reason that the immunity is removed is that whenever the Security Council refers a case involving a non-party to the Rome Statute, in effect, the Security Council makes the Rome Statute binding on that state. Why is that so? That is so because the court can only operate under its statute. So when the Security Council says the court has jurisdiction, what it means is that the court has jurisdiction under its statute. Every provision in the statute applies to those proceedings. It could not be otherwise because the court couldn't operate under some other body. And because the statute is in effect made binding on that state, that includes Article 27. It includes the provision in the statute that removes immunity. And it's on that basis that I would argue that under Article 27, states that the Security Council, with respect to which the Security Council has made a referral, are bound, that the immunity of the head of that state has been removed. Just a closing word about the South African decision of last week. Now, the view that I've just expressed is one which the Supreme Court, they didn't go that far. In fact, what they did was, in effect, they first of all said, well, let's look at the position under customary international law, and then decided that they didn't want to run in advance of customary international law. There's no customary international law exception. And then they reached the decision solely on the basis of the South African legislation, or at least they claim to reach the decision solely on the basis of the South African implementing legislation. What's interesting to me with regard to that decision is that they almost seemed, and I won't put Max on the spot here because he was counsel, but the Supreme Court almost seemed to go further actually than counsel was arguing for in that case, because the Supreme Court seemed to suggest that on the basis of the South African implementing legislation, even in non-ICC cases, I think one can imply that even in non-ICC cases, they seem to be suggesting that Section 4.2 of the Implementation Act would deprive the head of state of immunity. And I'm not sure that international law goes that far. I think in ICC-related cases, yes. In non-ICC cases, I don't think it goes that far. But we can talk about whether that's a right interpretation of that decision or not.
Okay, thank you, Dapo. Next, we'll have dear Tladi.
Well, thank you very much, and thank you, Bettina, for insisting, notwithstanding my protestations, that I come in for this particular session. I had actually intended to speak about the judgments and the treatment of international law in the judgment. But in light of the discussion that was had last night that I speak after Dapo, I thought it would probably be more useful to respond just in a few words to a couple of things, and then if there's time, I'll say a couple of things about the judgment. In general, I agree with sort of the general scheme of the framework that's applicable with respect to immunities. I want to particularly emphasize the point that Dapo makes at the beginning, which is a point that I must say I struggle to explain to people. And that is that essentially there are two separate questions, and those two separate questions with respect to immunity have two different answers, depending on various variables. The one question relates to the immunity before the court itself, the ICC, and then the other one relates to the immunity before domestic authorities. And I think these are two critical questions. If one listens to a lot of discussions on this issue, people say, well, there's no immunity, and why is there no immunity? Because of Article 27, implying that there is no immunity even before domestic authorities. And that seems to be what at least the High Court decided. Now, what's interesting, of course, about these questions, as Dapo mentioned, is that the ICC pretrial chambers themselves have taken different postures. So in the first one, in the Malawi and Chad cases, essentially what the court said was that because of Article 27, or Article 27 reflects this idea, that there are no immunities before international courts, and therefore, because there are no immunities before international courts, there's also no immunity before domestic authorities. The DRC pretrial chamber essentially reverses this in a kind of a dangerous way if you're interested in limiting immunities, right? And so they go from one extreme, saying, well, there's no immunities, to another extreme saying, Article 27 does not apply to heads of state or other officials of non-state parties. As I understand it, that's the position that Dapo takes. But there is actually nothing in the statute that justifies that conclusion. I mean, if you look at Article 27, it applies to all officials, right? It regulates the relationship between the accused and the court, and does nothing more. So the whole question about immunities and immunities owed to states doesn't come into play, because essentially it regulates the relationship between an individual and an institution. Now, Dapo makes the point that there is certainly no customary international law position removing immunities before international courts. The question that I ask is whether the fact that there is no customary international law removing immunities before international courts implies that there is in fact a customary international law obligation requiring the respect of immunities before international courts. And there quite simply isn't, right? There quite simply isn't. The rules relating to immunities were developed in an interstate context. So that's the rationale, right? The rationale was to ensure states to be able to relate to one another. Moreover, if customary international law is based on practice and opinio juris, there is certainly no practice to the effect that there is immunities before international courts. There is not a single international court that I am aware of, and that's practice, which provides for immunities before international courts, which suggests that at best there is simply no rule relating to immunities before international courts under customary international law. The question then is, where do you find the rule? And the answer to that question is, well, you find the rule in the instrument establishing that court. So for the ICC, you find the rule relating on immunities before the international courts in the ICC statute itself, and that will be, as Dapo mentioned, Article 27. So there is no customary international law one way or the other. You would have to look at the instrument itself. Now, Dapo argues correctly that Article 27 removes immunities even at the domestic level for states parties, and I think that's correct. I think it's correct for the first reason he gives, right? As a matter of treaty interpretation. I am very concerned about the practice that I see of people interpreting instruments by means of pragmatism. What is practical? But if we interpret it this way, it will be redundant. The fact is that there are rules of interpretation. Those rules of interpretation are to be found in the Vienna Convention, and they tell us how to interpret an instrument, right? So if you look at the Vienna Convention, I would certainly be convinced Dapo's argument that immunity for states parties is removed even at the national level because states parties have so interpreted Article 27, right? And so by means of the interpretation that I think all states parties to the ICC have accepted, there is no immunity even at the national level under Article 27. I don't think that it's because of redundancy, right? One, because I don't think that's a rule of interpretation, but even if it were, I don't think that Article 27 would be redundant if it could not be applied to remove immunities of non-states parties. And the reason for that is simple. Such an interpretation would suggest, in the first place, that the sole purpose of the ICC is to prosecute individuals with immunities, and that's not the sole purpose. That's the first point. The second point is that it is foreseeable to see the application of Article 27 and Article 99 to a head of a non-state party, right, through a Security Council resolution that is properly drafted. And I'll come back to the point that Dapo makes about the implications of Resolution 1527. Is it 1527 or 1597? 1597. So I'll come back to that particular interpretation. But the argument that Article 27 would be redundant if Article 98 were applied in such a way as to exclude immunities, I think is for me rather problematic. Now, Dapo is correct that the DRC pretrial chamber reversed its finding with respect to the scope of Article 27, but, and I think this is an important point, to arrive at a particular position, it then decided to adopt a new way in which it could incorporate Bashir, and that new way was through what I think is an expansive interpretation of the resolution that referred the situation in Sudan to the ICC. The court concludes or finds that the second operative paragraph of that particular resolution, by requiring Sudan to cooperate with a court, essentially requires Sudan to waive immunities. Of course, it doesn't make the jump to say that Sudan has actually waived immunities, and of course a waiver cannot be implicit. But that interpretation is simply not justifiable either. And it's certainly not the interpretation that's adopted by the states that adopted that particular resolution. There are Security Council debates on the situation in Darfur and the prosecutor's report, and the only state that has ever raised the issue of immunities in that context is Russia. And there are no prizes for guessing what the view of Russia is, right? The other states have simply never supported this interpretation. There have been countless opportunities for the Security Council, in light of the arguments that have come from the African Union, to correct, if you like, the misinterpretation by adopting a press statement or whatever the case may be. The Security Council has simply not bought into the interpretation. So to give that particular paragraph an interpretation that is not accepted by the drafters, I think is problematic. But I also do not accept Dapo's argument that the mere adoption of the resolution referring the situation to the ICC places Sudan in the position of a state party. That's simply not justified either. The only thing that a resolution does is it grants the court jurisdiction over the situation. That's all that it does. It does nothing more or nothing less. Now, Dapo says that the result of this referral is that every provision in the ICC statute should apply, and that's absolutely correct, right? But that means that Article 98 also applies. And Article 98 is just as much a part of the Rome Statute. And if Article 98 applies, then to the extent that there is a duty to cooperate on states parties, that duty is, by the operation of Article 98, limited by the rules relating to immunities. I want to say a couple of things about the court, even though there's 2 minutes left, I think. I want to say a couple of things about the decision of the Supreme Court of Appeal last week. I think on the international law questions, at least all with respect to the rules relating to customary international law, I think the court gets that right? I think the court reverses, although it doesn't want to say it reverses some of the incorrect decisions of the High Court. But the court does reach a strange interpretation of, and this is one text that we haven't spoken about, it does reach a strange interpretation of the host country agreement that was entered into by South Africa and the African Union. Essentially, it interprets that host country agreement in a way that no host country agreement, I think, has ever been interpreted, to say that it grants immunities to everyone else except the delegates to that conference. I mean, that is the strangest interpretation, and there's certainly no way that a host country agreement can be interpreted in that way. What's particularly strange for me is that the court, in light of the findings that it makes with respect to the domestic law, didn't need to actually arrive at that very strange interpretation. I mean, it could have said, we accept that this host country agreement, this treaty, applies to Bashir, but it doesn't matter because of the domestic legislation. I won't say more about the domestic legislation, but I do have some views, so I hope at least when it comes to question and answers, I can say a few things about that. Thank you.
Thank you. Max?
Thank you very much. I'm in somewhat of an awkward position because it seems as though, at least from what one hears in the grapevine, the South African government may well be intending to appeal last week's decision to the Constitutional Court. So as having acted as counsel in the case, I don't want to be seen to be in any way critical or supportive of the judgment. I think it's a great one, but beyond that. But I don't want to speak about it. So what I'd rather do is I'd take this opportunity to reflect on 4, I think, important points that arise out of the judgment, because of the judgment, or despite the judgment. So I really just want to give you 4 reflections. The first reflection is around the rule of law. There's much academic debate, as we all know, about immunities, what it means in international law, and that debate has continued today. Very fruitful discussions between Dapo and DIRE, and it will continue and keep academics in business for years to come. There's no question about that. And the debate centers on what the arrest warrant decision of the ICJ means in 2002, whether it's still the same position under customary international law today, and what is the status of immunities under customary international law, something that the International Law Commission is considering closely at the moment. So that academic debate is alive and well, but with respect, I think, at least in relation to this case, it misses a number of important facts. And it misses, I think, the important fact that we had a chance to arrest al-Bashir, and that didn't happen. And those facts, that's why I've called this first point a rule of law point, those facts are rule of law points. And I want to stress that. It's something that Jim Goldstone was saying in one of the debates we were having in the past 2 days, that we sometimes forget that this is about the rule of law. And those rule of law facts are twofold. The first rule of law fact is that at the time that the Pretoria High Court was faced with President al-Bashir's presence in South Africa, at the time that that court was considering what to do about customary international law and the positions around our implementation legislation, at that very time it had already issued an order directing that President Bashir would not leave South Africa until such time as the case had been concluded. That order, as we know, and as the High Court judgment confirms, was flouted. So there's a rule of law problem right there and then, when you have a flouting of a court order, and it was flouted, as the High Court made clear, through the assistance of South Africa. South African officials, at whatever level of government, appeared to have been involved in assisting President Bashir in escaping from South Africa over the time of the AU conference. That's the first rule of law fact. The second rule of law fact is that whatever the debates may be about customary international law in the ICJ and elsewhere, and amongst academics and the various writings of learned scholars, there was a pertinent decision of a court. And again, I'll stress this as a rule of law point. There was a pertinent decision of a court in the form of the pre-trial chamber of the International Criminal Court that had issued an order backed up by a decision which referenced an earlier decision in the DRC case, in which that court said South Africa knows what's happening, is perfectly aware of the position as the ICC sees it, knows that customary international law, so far as the ICC is concerned, does not in any way protect President Bashir, and that President Bashir's immunities are stripped, said the court, because of the Security Council resolution debate, the Dapo Akande position, reflected in that judgment. And that order was issued against South Africa on the eve of Bashir arriving in this country. So it's a pertinent international criminal court decision by a chamber against South Africa in respect of Sudan and Bashir, the man. And it is a decision which expressly says that you judges, you academics, whatever you may think, you government lawyers in South Africa and all the protagonists and antagonists, whatever you may think customary international law debates may mean, for the purposes of this case, this state party, this accused, and the debates about his immunities, it's irrelevant. We as the ICC have decided that he does not have immunity. And you as South Africa are a party to the statute. You recognize the authority of that court and you should implement accordingly, and you should act appropriately with fidelity to that decision. That's a rule of law point. So 2 court decisions expressly flouted. In the teeth of those decisions, the South African government said, he's got immunity, we don't care, and we'll let him out the country at the same time. It seems to me that those are significant rule of law points which we sometimes miss in this debate, interesting as it may be, about what the state of immunity might be in international law. That leads to my second point, and it's a related rule of law point. It's about accountability. We've, in this entire debate, been focusing on Bashir's accountability and whether, despite his what apparently seems to be clear accountability that he should ultimately have in respect of these crimes, there's this debate about whether any accountability can be achieved because of an immunity that he has. So the debate is about Bashir's accountability. It seems to me we're missing a new and a very different level of accountability in this discussion. The High Court, as you'll recall, was so upset about the fact that its order was flouted by the South African government allowing Bashir to escape, that at the end of its decision, it said that it doesn't find the South African government's reasoning for how Bashir left the country in any way persuasive. In fact, the High Court said that the South African government's decisions in this respect and its conduct seemed risible, and the government, through the National Prosecuting Authority, was requested by the High Court to consider bringing appropriate charges against those that were implicated. That's the High Court decision. The Supreme Court of Appeal last week went through some of the same history and came to the same conclusion. It suggested that the South African government or its lawyers in the court had misled the court as to whether President Bashir was in the country, and they had clearly, it suggested, facilitated his removal from the country. And again, the Supreme Court of Appeal said, it seems that there would be a requirement for the professional bodies, in other words, the Bar Council and the Law Society, to investigate the lawyers that had made these statements to the court and given these undertakings that Bashir was still in South Africa. And secondly, that the National Prosecuting Authority should be encouraged to consider bringing appropriate charges against the individuals concerned in this matter. So there is an accountability question that arises at a different level, which is an accountability level that is something that really is quite striking. If a murderer arrives at my door, and I know there's an arrest warrant for that murderer, and I say, come on in and have dinner. And halfway through the dinner, the police arrive and they knock on the door and they say, is this murderer that we're looking for in your house? And I say, no. And I say to the murderer, there's a garage in the back, go and hide there, and I allow him to escape. I've become an accomplice after the fact to murder. And I don't think there's been sufficient thought about whether the officials involved in this case have made themselves accomplices after the fact to genocide. It seems to me it is something that requires at least some consideration. I don't pretend to know the answers, and I'm merely raising it as a point of accountability, but it seems to me that it is a message we may wish to send a little more firmly to individuals who think they can play around with this type of offender and assist this type of offenders escape from a country where, had they not facilitated that person's escape from the country, we may find al-Bashir right now in The Hague before the ICC, where he does not have immunity, being prosecuted for genocide. The third point is the regional context. I think we mustn't forget that this debate and this case arises out of the African Union's position in relation to al-Bashir. And we know there's the Malabo Protocol. We've had discussion about the Malabo Protocol. It reflects a turn to immunity for African leaders. I think the Bashir debate and the Malabo Protocol together are going to have two insidious effects. First of all, there's going to be a hardening of the position of, I think, continental leaders in relation to the immunities for African elites. There's going to be a push for African elites and their immunities to be recognized. We've already seen that, of course, through the Malabo Protocol. And relatedly, the second consequence is there's going to be an African push for an African court as being an African solution to African problems. We've seen that push already. African solutions to African problems. It's a solution, immunity, for an African problem, a problem felt by leaders, African leaders. It's not a solution dreamt up or progressed by African victims of these crimes. It is a solution that is pushed hard through the AU and through its lawyers. It's a solution for elites. And I think there are obvious problems with this idea of an African court, and an African court in respect of which these African leaders do not have any form of accountability because they have immunity there. And we know the problems. They're twofold very quickly. The first problem, and it's been said, but don't worry, this immunity that pertains before the African court is just a temporary one. It's only while that person is still in power. Well, of course, that's a counterintuitive. It's going to incentivize these leaders to stay in power. It's obvious. It's a perverse incentive to cling to power when you've committed these crimes. And it's not a little ironic, I must say this, it struck me this morning as I was thinking about this, that this protocol was signed in Malabo, in Equatorial Guinea, where the president is Theodore Obiang, who took power in 1971, 45 years ago, and is still the president there. I mean, it really does say it all, doesn't it? The second problem with the African court idea is, of course, something we've debated already. The African court is hugely problematized. The protocol to create the African chamber is shot through with a whole bunch of legal difficulties. It was rushed. There was no civil society support. There are huge problems with the idea of costing this to make it an effective court. There are massive problems with its overstretched jurisdiction. And, of course, as Charles Jalla and others pointed out, there are important features, progressive features of the statute. But really, let's not feature too much on those. It's a bit like trying to put lipstick on the pig. The machine itself is quite obviously intended to scupper the ICC and to act as a form of, I'm sorry to say this, you may disagree with me vehemently, but it will, even if it doesn't have this as its motive, it will have it as its effect. It will be a form of cynical, negative complementarity. It will allow African states, instead of becoming a member of that court, to instead find themselves confused about whether they should be ICC members or African court members, and at the end of the day, that's to the detriment of the ICC. And as Alan and Gary pointed out, there is no forum shopping potential here. There is no other court but the ICC presently that allows any form of justice for these victims. So let me conclude then by saying that it's a victory for now. The Supreme Court of Appeal's decision is a victory for now, but I must say, I think you must gird your loins. We've got to renew our efforts in a number of respects, because I think the terrain is clear and the battle is really just about to begin. You've got to take seriously what the motives are behind the African court and the amendments thereto and the African protocol. I think you've got to resist, as states, signing up to the Malabo Protocol. And at the end of the day, you've got to do that which lawyers in international criminal justice have done for years, and that is to recognize that you've got to be patient. The law is, in this context, is patiently waiting to ultimately do its work in respect of these officials. As Adolf Eichmann said, 15 years after he'd been hiding, and eventually the prosecutors caught up with him. And as they found him 15 years later, his first reported words to them were, "I've been waiting for you." He knew they would eventually come. And the same is true for President Bashir. He can run, he can hide, he can have his lawyers do what they want. But at the end of the day, the law will eventually catch up with him. And then too, he will get a chance to turn around and say, "I've been waiting for you," because we've been waiting for him. Thank you very much.
Thank you. Chris?
Thank you so much, and thank you, Bettina, for the invitation. So I want to change tack slightly. I'm tempted to engage in this very fascinating debate, and I have points, and hopefully you'll allow me to raise some points in the discussion. But I wanted to talk about accountability of a different kind. So what I want to speak about briefly is accountability of civil society, and what immunity presents as an opportunity for civil society, for us as civil society, to think critically about what international criminal law does in the world. And I think there's two reasons why this is a very important moment to do this. The first is that for all the hubris and celebration about the International Criminal Court, there hasn't been a lot of reflection, I think, critically within civil society about precisely what the International Criminal Court does. And I think there's a tendency to paraphrase David Kennedy, to think of the International Criminal Court as an object of devotion, as opposed to an object of calculation. Right? So it's something we devoted to. There's faith in the International Criminal Court, but there's not a lot of reflection, at least within the church, as to what precisely it does in the world. And I think this is an ethical responsibility of members of civil society who do good business out of these debates, just like academics do, and I would add advocates do as well. We all do good business out of these types of debates. And I think there's an ethical obligation on civil society to reflect, perhaps at this moment and always, on what exactly international criminal justice does in the world, and the kind of world that it orders and reorders. And I'll talk about that in a bit more detail in a moment. The second reason why this is very important is, I think, because the International Criminal Court, having operated for just over a decade, is moving into its own as a source of power. So it's been operating, I would argue, more or less for a while in the shadow of power, but it's developing its own institutions, its own politics, its own understandings of its role in the world, and I think it's an important moment for us to think about what that means. So there's been discussion amongst academics about how the International Criminal Court is moving to a more cosmopolitan model of international justice, from one that's based on state consent to one that is more or less evinces its own political framework, its own political institutions as well, and I'll talk about that in a moment. The third reason why this is so important is because in the context of immunity, the stakes are incredibly high. So if you think of this as a cost-benefit exercise, the cost of arresting al-Bashir, both for Sudan and for South Africa, would have been significant. And I think those costs alone warrant us to reflect precisely what it is that international criminal law does in the world, whether it does it well, how we can do it better, not simply just as a critical exercise because it's fun to be critical, but as a diagnostic exercise to understand the role that it plays. So what I'm going to try and do is sketch out 5 features of the International Criminal Court, or the International Criminal Justice Project more generally. I'm going to try and not be critical. I'm going to try and reflect on these as objective, a diagnosis, if you will, so we can understand precisely what it's doing in the world, and then we can reflect on how it works in the context of immunity. So the first thing is to say, which I've mentioned already, is that the International Criminal Court is an exercise in cosmopolitan politics, increasingly so. It's cosmopolitan in 3 ways. It's morally universalist, so it presumes a moral universality. It's individualist, it assumes that individuals are the unit of measure in a political system. And it's general, it assumes that the best way to achieve the advancement of the individual in a morally universal sense is through a general institution. So it looks beyond the state. It has a very sort of practical relationship with sovereignty. And the ICC, you can see, has moved along this trajectory from one that was based on state consent to one that increasingly is having a functional relationship with sovereignty. So the ICC likes, for example, the Security Council's exercise of sovereignty, or states on the Security Council's exercise of sovereignty in respect of referrals, doesn't so much like complementarity as an exercise of sovereignty. Right? So it's moving, and McAuliffe has called this a creeping cosmopolitanism. So it's moving towards a cosmopolitan court that doesn't necessarily have the same kind of consent-based justification. And I think as proponents of the court, this is a good thing. There's always been a slight problem with relying too much on state consent. Right? So if you rely on state consent in the context of the anti-Africa ICC argument, it only gets you so far. It's a great legal justification, but if states withdraw their consent, then all of a sudden you don't have a foundation. So as a practical exercise, or as I guess a tactical exercise, I think the ICC's move to something beyond relying on states for its legitimacy is a useful thing. Where it finds its legitimacy is the next question. So that there's more or less two ways that the ICC tends to ground itself. The one is in terms of some appeal to a universal, right? On behalf of some amorphous international community, what Fred McGray has called the most imagined of imagined communities. So some kind of ahistorical assemblage of people or assemblage of nations for which it speaks, on whose behalf it speaks. The other way that it does this is in terms of representation of victims. So it now speaks for victims. No obvious connection of democratic representation, but victims as a figure are represented in the court's rhetoric. And it tends to move between these two, from saying we're acting on behalf of a whole, an unspecified whole, collectively called the global international community, or on behalf of victims. And these are the two ways that it tends to ground its legitimacy. What that means is that, and this is not a critique, this is an observation, what the International Criminal Court is doing is drawing on a particular type of late 19th century liberalism. It comes from a particular political space. I'm not saying that makes it neo-colonial or post-colonial, I'm saying it's a fact. This kind of universalism has a particular history and it comes from a particular place. Right? We can say that we can transcend that, but we can't avoid it. So again, I'm stressing, this is not a critique, this is simply an observation. It comes from a particular view of history, the unfolding of history, and the role of international law in it. It comes from a particular view of society and how society should be formed, and the role of criminal law in those. So it doesn't come from nowhere. It's not a view from nowhere, it comes from a very particular place. So that's the second point. The third point, which I made yesterday, and again, this is not a criticism either way, but what international criminal law does is appropriate the authority to define what's wrong with the world and to present solutions to those problems. And increasingly what international criminal law does is define the worst thing that's wrong with the world. Right? So the problem of the world is a problem of impunity. The problem of the world is a problem of lack of reparations. The problem of the world is a problem of evil men. Right? Now, and I'm not saying it's wrong, but I'm saying in doing that, what it's doing is displacing other diagnoses. So for example, we talk about justice all the time. There is a 40-year-old movement for global justice, which has nothing to do with international criminal law, and it's a movement about redistribution of resources. Right? So when you have a particular focus on the criminal sanctions, you sideline other projects that diagnose problems in the world. Right? This becomes the seminal issue of our time as a problem of justice for individuals, or against individuals for groups, unspecified groups, not a problem of redistribution of welfare or wealth. Right? And so in the process, there's kind of a pushing out of other types of projects. We saw this yesterday in the context of reparations. Reparations, again, a very long debate that goes back very far, and people have written a lot about reparations for slavery and colonialisms. Reparations as a debate is now being funneled through the International Criminal Court. Reparations in terms of victim reparations for specific crimes. But that automatically means that all the selectivity of the ICC becomes a selectivity of reparations. So there's kind of a sense that it's crowding out a particular space. It's defining problems in a particular way, and it's defining solutions in those ways. And it defines a solution in relation to what it sees as the particular problem. Now again, I'm not saying that's a good or bad thing, I'm saying that's what it's doing. Right? It's not a sense of saying this is not the only way to do it. It's not self-evident to me that the worst problems in the world are X, Y, Z. We can have debates about this, and we tend to call those debates politics when we debate what's the worst thing in the world and how we should address it. We can't say politics within international criminal law circles, but that's essentially, to me, what's going on. So the third related question, or the related feature of the international criminal law system, is that because it sees itself as a universal cosmopolitan, but a project in the making, it relies heavily on a particular institutional framework, right? So it rests on top of a world of states. And it's a universal project in its aspirations, but it's very much in its manifestation based on hierarchy. So we can see that we know this through the most obvious version, is the most obvious emblem of this is the Security Council, right? So the International Criminal Court rests on a global governance structure that we know to be unjust, that we know to be problematic, that we know to protect certain interests. Again, this is not a criticism, this is an observation. It cannot function without the Security Council. The International Criminal Court could have said from the beginning, we don't recognize your Westphalian system of states, we don't recognize the Security Council, we don't recognize your mechanisms of global justice. It hasn't. It rests on that, it relies on that, it exists again to some extent in the shadow of power. Right? It happily accepts Security Council resolutions. It doesn't challenge the jurisdiction of Security Council resolutions. It does that because I really believe that there's a kind of ends justify means logic. But you can't not observe that that's what it's doing. It rests on a particular, or operates in a particular institutional governance framework. And we know the problems of that, so that's perhaps one way to think about it critically. And the third way, and I think this is, the final thing that international criminal law is doing in the world, or how it operates in the world, is through a particular type of language. And I think as civil society we should be aware of this. So what international criminal law does is diagnose problems as crimes and then empower lawyers to solve them, or diagnose problems as particular technical problems, not political issues. These are technical issues involving very technical questions that only elite people can answer. So we can talk about the International Criminal Court as protecting elites, but it has a very productive role in producing a class of elite lawyers and civil society members and educated people who then make careers out of doing the business of international criminal justice. Right? That is what it does in the world. We can again say that's a good thing or a bad thing, but it's a fact. It does produce certain elite politics. It does, to some extent, depoliticize those issues by making them legal questions. And I'll say this for the final time, not a criticism, but to me this is an observation of what it does in the world. We might think it's a good thing. We might all think a meritocracy is the best way to organize society, but we can't pretend that doesn't happen, and we can't pretend that that's not a political question. And in the process that it doesn't in some way bind us into certain ways of thinking about the world, certain politics, certain languages, certain practices, certain places, right? So we go to The Hague becomes the center of where the world's problems are solved. I couldn't help but think when Max was talking about Malabo as an inauspicious place for the African Court Protocol, I was thinking about The Hague as being an inauspicious place for international criminal law, because the very first criminal trial that would have happened after the Treaty of Versailles didn't happen because Kaiser Wilhelm got asylum in the Netherlands. So you could speak about these historical anomalies the whole time, right? There's no particular good place, no one's hands are clean. So those are the 5 things. So what I wanted to raise those for questions, because I think once we think of international criminal law in that broader sense, if we step outside the church, if we think about the role it plays in the world, then we can have a conversation about immunity. Right? So when we calculate the costs of granting immunity, the costs of removing immunity, we can't do it in kind of a faithful way. We have to be critical, we have to know what it's doing in the world, we have to know the costs in their true sense. And so I thought that might be one way to have a conversation perhaps that's more richer, and a reflection, I think, of civil society's role in producing all those effects and perhaps benefiting from them. Thank you.
Okay, thank you very much. We just heard 4 very different takes on this immunity issue. I have a few questions to ask, but I think I'm going to open it up. I see there are quite a few people who want to ask questions. So first, Mark. Okay. Maybe we'll take 3 questions and then let the panelists respond.
Thanks very much. Absolutely fascinating, everybody. Very interesting, too, because you get a sense of the insecurity of the field of international criminal law, in the sense that whoever ends up being right tomorrow or in 10 days or in a year, the field won't be the same, right? And so there's a lot more at stake than maybe any other form of international law. But what I wanted to ask, and this goes to Max's point about bringing accountability in, and so my question is for Dapo and Dire. You have positions, clear positions, and you come to different conclusions based on what you think the right interpretation of international criminal law is in this instance. But do you think your positions are just? Is there any sense that you think that they're, in a sense, just positions, or that they actually help international criminal justice? Not international criminal law, but do you think that do they represent justice rather than simply legal positions? And if so, how?
Okay, thank you, Mark. There was a question over here. Yep.
Thank you, Kathy Powell, University of Cape Town. Thanks very much for a very exciting panel, to all 4 speakers. I'd like to address 2 points. First, thanks to Max for the rule of law point, which really does get lost. I've always been flabbergasted that South Africa didn't acknowledge that it's under a duty under the Rome Statute to comply with decisions of the ICC, one of which was that it was under an obligation to arrest President Bashir. But the other one, responding to all your observations and not criticisms, Christopher, I suspect there was maybe a little bit of criticism in there. And I want to bring out two main issues. One is what you call 19th century liberalism is not the only source of this idea behind a universalist value that we're all trying to protect, this imagined community. Lots of current developments in international law are pushing that too. Constitutionalization, what you call cosmopolitanism, they are current developments. Even global administrative law, which claims to be pluralist, is pushing for certain combined values, because if there's no sense of a combined value, there's no sense of cooperation in the first place. So I think you're dissing it a little bit by putting it back to just the colonial enterprise. It's happening now. And it's happening particularly because states are state leaders are misusing the notion of sovereignty for personal gain. And in that context, you quite validly point out that the struggle for criminal justice might displace other forms of justice that are required as well. For example, redistribution. I'm with you there. You need redistribution to keep its focus. On the other hand, be aware of how international criminal law leads to a maldistribution of resources. Yeah, we had that yesterday. We had that when we looked at transnational crime. International crime and transnational crime and ivory smuggling, they all work together. So it's not as if criminal justice is coming in and being all sort of proud of itself and moral. It's actually doing some work in the world. And then finally, your point, you seem to suggest maybe state sovereignty is not the best basis for law, but on the other hand, yes, it should be, and the ICC is shifting from the one to the other, and should it be doing that? What you're touching on is a really deep debate about what international law itself is based on. The positivist notion that it's only state consent, the notion that tries to remove any moral element from international law, is deeply theoretically flawed. And there are a number of other arguments that try to suggest that law is inherently descending and not ascending, not just based on the consent of states. And I don't think you can find an area of law that is more inherently descending than criminal law. And we've got to accept, if we're going to have it at all, that what we've got are founding foundational values and other principles that lead from it downwards, not the other way around.
Okay, thank you very much. One question right here, yes.
I think for the integrity and independence of the International Criminal Court, we should campaign that the Security Council should have nothing to do with that court because of the hypocrisy. Some of the members have contempt for the ICC by refusing to ratify the Rome Statute. How can you then gather in America and say, oh, go and arrest Gaddafi or go and arrest that one when you do not believe in the Rome Statute? And that's number one. Number two, I think our debates will be enhanced if we also examine the attitude of some countries that have, before the al-Bashir case, shown disregard for international law. If you take the British government, the Thatcher government, with respect to the judgment of the House of Lords in the case of Pinochet, right? Instead of sending Pinochet to Spain for trial, what Madame Thatcher simply did, oh, this is our friend, I better deport him to his country, because this was a man who had conferred life immunity on himself. So we shouldn't isolate the African continent so that we do not also expose ourselves to the attacks of all these big men in power in Africa who do not want to be accountable. The last one for me, Dapo. Yeah, just this one. I think we should also look at immunity in each of the African states. To what extent are our presidents or prime ministers immune? In the case of Nigeria, no president enjoys absolute immunity. Under our own national law, a president can be investigated, and there is a judgment of the Supreme Court of Nigeria to that effect. In each of the African countries, a president can be challenged to justify the legitimacy of his election. Right now, the big man in Uganda is facing trial over alleged rigging of election in his country, and judgment will be delivered on the 31st of March. In Kenya, President Kenyatta, who is challenging immunity with respect to ICC, did not enjoy immunity with respect to his own election. He was taken to court, and the court gave judgment. So I think it's important for us to look at how the courts in our countries have whittled down the immunity of our sitting heads of state. Thank you.
Okay, thank you very much. We're going to I'm going to let the panelists respond, and then we'll take more questions. So maybe let's start with Dire.
Okay, so there was one question that was specifically directed at me, but I would, if you permit me, also comment perhaps on at least one or two things that Femi said. So my starting point is the law, right? I mean, I think one of the difficulties with discussions about the ICC is what I refer to as sort of the hero-villain approach. I had a debate with one professor a couple of months ago, and he said, well, Bashir is the devil. And that may be true, but I guess the question is sort of what does that mean for the law? Does that mean that we ignore the constraints that have been placed on the law in order to get to the devil? I would say no, because if we do that, then maybe we don't need the ICC. Then maybe all we need is, if we see him, just shoot him, right? There's a reason why we have rules, and there's a reason why we have laws, and I think we have to respect the constraints imposed by law. And I guess the appeal for the proper interpretation of the law, and not just an interpretation that facilitates getting him, is precisely to ensure that we respect the constraints. Does that mean that law should not have a moral content? Absolutely not. Law should have a moral content. My answer might be slightly different if we didn't have any rules at all, right? I mean, if we were in a state like a state of apartheid, I might say, well, we have to move beyond these rules. But the fact is, right now, we have a legal framework, a very good legal framework that is created to bring justice to those who perpetrate crime. In the light of the fact that we do have a framework, I think it's not justifiable to sort of stretch the legal rules beyond any recognition with a view to arriving at a particular position. So my starting position is, here we have a legal framework. We have to respect that particular legal framework. That legal framework contains within it a justice element. And so the issues of justice that you're talking about are integrated into the legal framework, and so I don't need to create them from elsewhere to make it work. I think that's the point that I'm making about immunities. There is a second consideration about justice. In a sense, I also think that if you stretch the provisions of the Rome Statute too much, beyond what those who ultimately have to carry them out are able to, you actually risk the system. I mean, the fact is that you had a judgment that was given in June, right? It was a judgment about the interpretation of the framework. That particular interpretation did not sit well with those that thought they understood it. They may well take a decision then, a sovereign decision, which they would be entitled to in terms of that framework, to say, well, if this is how you interpret the framework, then we're not going to be a part of that. We accept whatever wrongdoings it may have been, but then we engage in a process of withdrawal. I mean, I think that's a real fear. So in terms of also a thinking about justice and thinking about what's best for the system and the longevity of the system, I think one has to, and that's not to say that you shouldn't give the terms of the treaty their meaning for fear of causing discomfort. It simply says, give them the meaning that they actually have, and not more with a view to achieving a purpose. And it seems to me that a lot of what we've seen has been an interpretation of the various instruments in order to achieve a particular purpose. I mean, take the pretrial chamber decisions, for example. You have a pre-trial chamber decisions in Chad saying one thing, severely criticized by everyone, even those that agree with the final outcome. The next time that same case or the same rules come before it, they do a complete 360 reverse but come to the exact same conclusion. I mean, that should tell you that the outcome is predetermined. There is simply no way, regardless of what the Rome Statute says, that any court is going to come to a different conclusion about the outcome as to if to arrest. And I think that's problematic. Femi, if I may.
Very briefly.
Yes, very briefly. You make a point about the members of the Security Council refusing. I think that's not the problem. I mean, for me, that's a sovereign right. But the problem is the undermining of the ICC statute by, for example, referring cases and not making certain things clear. I mean, the very reason that we're having this debate, the only reason that we're having this debate, is that it's not comfortable for the US to say there is a duty on all states to cooperate with the ICC. If you had that in the resolution, then for me there's absolutely no debate, right? But you don't have that. And why don't you have that? Because those 3 states do not want to have the obligation to cooperate. Stop there. Thank you.
Okay, thank you. We'll take this from left to right or right to left. So, Chris.
Thanks so much. So these are obviously discussions we can probably have afterwards, but just quickly, so you're right, there are other projects. I think those projects also descend from the same late 19th century liberal ideas about the world. So for example, the Martens Clause, right? The Martens Clause emerges in the 90s as doing a whole lot of normative and rhetorical work. It hadn't been around for a long time. It comes in at a particular moment in history, the end of the Cold War, this kind of vision of a new international order, the end of history itself for some. And so I think those projects are linked. I think what international criminal law has done, to some extent, has picked up where human rights couldn't proceed any further, right? So we had questions about the universality of human rights. That's problematic because of all the politics. But we know for sure that evil men must go to jail, or evil women must go to jail. So to me, it transcends some of the limitations, perhaps, of the other projects. So the second question about distribution, I'll leave that, we can talk about that afterwards. The third question about sovereignty in the ICC, what I'm interested in, and perhaps I didn't make this clear enough, is the role that sovereignty plays in the ICC's own discourse about its power, right? So how does the ICC understand its own relationship to sovereignty? I have a particular way of thinking about sovereignty myself outside of that, but within the ICC's own explanation of its existence, it tends to move from consent-based to other normative, so it kind of moves from apology perhaps to utopia. And in some senses, the International Criminal Law Project is both unapologetically utopian and utopianly apologetic, if that makes sense. In the sense that you have to be descending, criminal law is automatically descending, as you point out. Punishing bad guys is ascending. So it's both. It's both apology and utopia. It can't exist without the state, but it's trying to transcend the state in respect of particular crimes of universal significance. So I think it's trapped perhaps in between those two instincts of those two argumentative forms, perhaps.
Okay. Thank you. Max, do you want to respond?
If I might just say 2 things quickly. I mean, the one is the point about, I think, Femi, you raised this about do away with the Security Council and its involvement. I think part of the problem is that's going to obviously require a huge amount of advocacy and change. But I think we must also remember one thing, which is that, of course, when African states signed up to the Rome Statute, with its scheme and its framework, as Dire talks about it, they signed up recognizing, of course, with their eyes wide open, that the Security Council was part of this framework, with all of its problems, with all of its inequalities, with all of what Chris speaks about as the different dynamics, and that was all there. It was built into the package, and they took it on. It sounds, though, as they took it on so long as it worked in a way which didn't ultimately direct attention at them. That's part of the problem. If I can then just pick up on that in respect of something that Dire said, I mean, I think it's absolutely right. Of course, there's a framework, and we've got to respect the framework, and how that framework is interpreted is vital, and as lawyers, we have a duty to do that. I'm worried a little bit about what and I don't know that Dire is suggesting this necessarily, but it may be implied, and certainly is something that we see played out by states. It's what I'd probably call the spoiler position. We're in so long as it works for us. We're in so long as you don't come against us. And we're in so long as you don't use the rules and the framework against us. And we're in so long as you accept our interpretation of the framework. And I think there's the difficulty with the spoiler position, because it is fundamentally, for me as a lawyer, it runs counter to the idea of the rule of law. Because if Dire is right that there's a framework, It's not a political framework, it's a legal framework. Part of that legal framework is that there is a judicial body in the form of the pretrial chamber, whatever you may say about it, it's eventually getting to the right outcomes in different decisions, changing its position. At the end of the day, if you're a party to the Rome Statute, you recognize the authority of that statute and its courts. And when they make a decision against you, then as part of that framework, in advance, you've accepted fidelity to say, I accept the decision and I'll abide by it. That's a rule of law point. It's not a politics point. So I don't think there's place for the spoiler in that context. You don't get to say, I don't like this decision that came against me, so therefore I may stay in, I might remain part of this framework, so long as you start listening to my interpretation of it.
Okay, thank you. Dapo?
Yeah, let me just address Mark's question. So Mark, your question is very complicated. When you say, are our positions just? Which position in particular? And I raise that not to avoid the question, but just to point out the complexity. So even though I take the position that with respect to President Bashir, there's no immunity either before the ICC or with respect to national proceedings, that's not to say that I think that a position that advocates immunity is unjust. Because I do think that immunity of heads of states has an important role to play in international law and in international relations. It may have gone unobserved, actually. Dire and I have opposite positions, not on one thing, but in two things. He actually takes a much more narrow view of immunity before international tribunals than I do. It's just at the national level, with respect to non-parties, that we take an opposite position. So I, for example, take the view that under customary international law, there is immunity for heads of states before international tribunals if that state is not a party to that treaty. And I think that that is important, because otherwise what we would be saying is that 2 states, 3 states, 4 states can set up an international tribunal to prosecute the head of state of another country. I don't believe in regime change by force, and I don't believe in regime change by international tribunals either, because that's in effect what we're talking about. To the extent that we take the view that there is no immunity before international tribunals, which are created by states, then all we are saying is that 2 states, 3 states, 15 states can set up an international tribunal to remove, in effect, the head of state of another state. I don't think that that's conducive to good international relations. So when you say, is it just, if the question is whether immunity as a rule of international law serves important functions, my answer would be yes, it does. I just don't think that in this case, Bashir has immunity for the reasons that I gave earlier.
Okay, thank you, Dapo. I think that's an interesting point. I'll take some questions, but I just want to add something because I think it's a really important clarification, and it's not just an abstract idea. Recently, there was this proposal to establish a tribunal to try the perpetrators of the MH17 attack. And you can imagine a situation where the Netherlands and Ukraine sign a treaty to establish an international tribunal and then remove immunities of heads of state, for example, of Russia. The question is this an international tribunal? And does Vladimir Putin not have immunity before this tribunal? So I think it is important to really keep these distinctions in mind. But anyway, I will take a few more questions. It's a very interesting debate. First, Navi Pillay, yes?
I hate to break the flow of the conversation because for me it's all about the ICC and immunity. But from my experience, people readily understand that the law should apply equally to everyone, and that people in power shouldn't write themselves immunity. So they understand that. What troubles them is the politicization and selectivity. And I'll give 2 instances. One is, apart from passing a national law protecting their servicemen and women, the United States pressured states not to ratify the Rome Statute and to sign undertakings that they will not arrest and hand over any U.S. servicemen and women to the court. and that was done. You want US aid, you have to sign these documents. So that's one case of politicization. The other one is the arrest and detention for a short while of President Evo Morales of Bolivia. So he was flying, as you know, in his plane from Moscow after official meeting, and he needed to stop for fuel in one of the European states. The United States persuaded Europe to not to allow him to overfly Europe, essentially to arrest him because they believed that Morales was had Edward Snowden on the plane and he was trying to escape. Eventually, Austria allowed his plane to land on condition that they will search his plane. So there's the president standing in his plane. The plane was searched, no Snowden, and then they allowed him to leave. 3 ministers from the Bolivian government came to see me as High Commissioner for Human Rights, saying that I have to take up this matter because the human rights of the president were violated. And I found that very difficult to do because I felt this is a diplomatic immunity issue. So really, I felt I failed in that situation, but this is how national immunities work. They protect friends and target their foes.
Okay, thank you. We have a question right here. Two questions, I guess.
Yeah, just two questions. One, I have tried to read and understand this judgment of the Supreme Court of Bashir. And I wonder whether any of these experts can just precisely tell us what is the ratio decidendi of this judgment. That's number one. Number two, is there an inherent conflict between Article 27 and 98 of the Rome Statute? And are they irreconcilable? And thirdly, and the last one, would South Africa have been able, instead of arresting and surrendering al-Bashir, would it have the power instead to prosecute al-Bashir in exercise of the universal jurisdiction? And if so, would the defense argument of head of state immunity have been sustained?
Okay, thank you. Behind you.
Andreas Kutsidis, I'm an advocate in South Africa. I was also involved in the case, so I just want to ask a reflective question, and without any comment of my own. Dapo touched on it and links into the question that's just been asked about where the South African court went. And I think Malcolm Wallace in his conclusion ties it up, as much as there may be different parts of the judgment, he ties it up in his concluding statement. And effectively, if I can summarize what he says in paragraph 103, and then ask for some reflection on this, he basically says the following. As a consequence of South Africa's international obligations under the Rome Statute and generally, South Africa in domesticating has done two things. One is to remove any immunities, including head of state immunity, that would bar prosecution of international crimes in South Africa, and any immunities that would bar cooperation with the ICC. So two movements. He then says, I accept, given my earlier comments, that this movement is going beyond where he says many other nations have gone, but he says this puts us as South Africa in the vanguard of attempts to prevent international crimes. And he says it's wholly consistent with, and this is quite an interesting move which we haven't reflected on, he says it's wholly consistent with South Africa's commitments in terms of human rights, both domestically and internationally. That's an interesting, so he's effectively using international human rights as his movement to justify South Africa taking a position which arguably is accepted is inconsistent, or at least going beyond the uncertainties found in international criminal law as to immunity both domestically and qua assistance. And he says that therefore, he concludes, this is to be commended as it's a departure in a progressive direction. So, I suppose I'm asking two questions. For a general reflection on that move by South Africa, which is a very progressive move, and secondly, what the implications are of that international law, because of course we know that a move like this arguably has both state practice and opinio juris implications, because he's not just making a state practice move, he's making, I would say, within Chatham House rules, I would say potentially an international human rights move, because he's suggesting I'm grounding this move based on another stream of international law, international human rights law. That's my question.
Okay, thank you. Let's take maybe one more question. Charles Jello.
Thank you so much. Great panel. I just wanted to raise two questions, and of course I invite the panelists to comment on this, but they're principally directed firstly to Dapo and then of course Dire. The first issue, and it kind of builds on the end of the comments that you just gave, Dapo, about customary international law and this idea, which Patryk re-emphasized, about a smaller group of states, I guess in that instance, two states coming together to create a tribunal, and the question of immunity. And I think that is very important for two reasons. One, of course, we've discussed whether the Rome Statute basically follows in its entirety a referred state. So I'm thinking the Sudans and the Libyas of the world. The difficulty, of course, is, as Dire, I think, was suggesting, you still have to resolve the customary international law question that comes up, where it's an explicit directive to the state, to the court itself, not to place states in a position where they'll be required to essentially violate international law. So my question is, in circumstances like that, I guess one could go through all the legal gymnastics to get to the solution. But isn't it simpler for us to say, when the council makes a referral, because it's using an extraordinary power, it ought to be very clear about what it is doing. So because we know by its very nature, the referred state is probably going to be dragging its feet. And this is not going to be a problem of whether it's Sudan or Libya. If you referred the United States today and somehow didn't have the veto, the US would be that feet-dragging state. And we've seen the US come under the hot seat when it came to international obligations in terms of the Guantanamo Bay, Abu Ghraib, and all of that. And we saw the same kinds of legal gymnastics that sovereigns would do. So the question for me then is, isn't it simpler, because of the extraordinary nature of the power that has been exercised, for us to demand from the Council the clarity? Because essentially you are going a bit further than what international law requires. You're doing an indirect consent. The very nature of the Security Council's authority is an indirect consent. It's by fiat of acceptance of the Charter itself. So I wanted to maybe tease some commentary from you on that issue. The second issue is about international law broadly and how it ties to the immunity. Okay, I'll be very brief. And I wanted to suggest that I'm not so sure that the AU attempt, and I don't want to open a big debate I would not be able to resolve here, and the AU approach is necessarily inconsistent with international law. Maybe if you look at Article 46A base, beyond the Troika, I have, I think, no argument I could make there. But what about the Troika, right? And they are giving temporary immunities, and it will be consistent, arguably, with arrest warrant. And I want to end with the point that if we look at that, is it different from what happened in the ad hoc tribunals, ICTR Kambanda, ICTY Milosevic, SCSL Taylor? In effect, in reality, the leader is never handed over when they are in power. So I wanted to see if you have comments on that. So in a sense, how outrageous is it in light of the practice itself? Not the rule and where we aspire to go. We all want to go there. But what is the practice? The practice is you essentially have that temporary immunity, basically. So how difficult are we really, how much are we really expanding the scope here in terms of the actual reality on the ground? Thank you.
Okay, thank you, Charles. I'll take one more question because I didn't see your hand earlier.
Thank you very much. Fantastic, fascinating panel. Congratulations, all of you. I think, Bettina, this really does show that this meeting was totally necessary, and we will continue to debate these issues. My first question, Dapo, please just tell me if I'm wrong here, because I'm now wearing the hat of an advisor to a government which is totally committed to the ICC, which is struggling with implementing legislation. I think the ISS knows we've been trying, we want to enact the right thing. You are a state party, you are, you don't have implementing legislation, you want, so Article 27, as far as you are concerned, lifts the immunity of my head of state. Who doesn't mind? He wants it lifted, okay? He wants to go to the ICC if he does bad things, and future presidents after him. He has no problem there. But in our implementing legislation, we are struggling with the fact that our constitution says that he's immune. We don't want to take two processes to the Parliament where we are doing both the implementing legislation and repealing Section 41 of our Constitution, which you are right, Femi, does not give total immunity on everything. So we want the implementing legislation without unraveling the Constitution. But you say, and I have argued this, and I hope I understood you correctly, that even if we did that and we didn't change our Constitution and we had implementing legislation, which is in any event subsidiary to the Constitution, he still has no immunity anyway. Is that what you're saying? And if it is, I want to ask Max, your judgment, two lessons for me. First of all, the lesson to be learned there is your implementing and domestic framework must be robust. If, as a country, you are serious about dealing with impunity and making sure. Two, and I would advise a government I work for, be careful, or a government I don't work for, who your friends are, who you associate with, who you invite. And thirdly, be careful what you sign, because your judges, and in this case I'm proud of the South African judges, will interpret this genuinely in the usual way in which courts do, to say this must have been your intention. You must have meant, you know, what you signed, these obligations. Thank you.
Okay, thank you very much. Interesting questions. We have 15 minutes, is that correct? I just want 10 minutes. Okay, so please, I'm going to ask the panelists to be brief, and we're going to start with Dapo.
Okay, I'll just pick up on a few things in the interest of time. So let me start with, maybe I'll start with Atalia's question. Your question raises the whole question of the relationship between international law and domestic law. So I was speaking of the position under domestic law, under international law. So my point was that under international law for parties to the Rome Statute, that immunity is removed not just at the international level, but also at the domestic level. Now, of course, that position, international law position, should be reflected in the domestic law, but the problem comes when it is not reflected in the domestic law. So, for example, if you have a constitutional provision that seems to be inconsistent, then you have a problem. Now, some countries have actually amended their constitutional provisions on precisely this issue. But that's the difficulty. How do you merge your international obligation with what your domestic law provides? Charles's point about the referred state would be dragging its feet and a demand for clarity. So I agree with that. But I would perhaps even go a bit further to say that it is precisely because, by definition, the referred state is not a party. By definition, the referred state has not given its consent. By definition, the council is giving jurisdiction to the court to exercise jurisdiction under the statute. It's precisely for all those reasons that I say that it is a necessary implication. It could not work any other way. When the Security Council refers a case to the ICC, it's a necessary implication that every provision in the statute then becomes binding. And in some ways, actually, I would myself not argue for that clarity, that the Security Council should start to say, we think this provision applies, that provision applies, that provision applies, because everything applies. Why would we pick out just the provision on immunity? Why don't we pick out all the other provisions in the Rome Statute? You know, so I actually think that that demand for clarity, which says, oh, and immunity is removed, arguably puts in question the application of the other provisions of the statute. Unless you say the clarity is the clarity that explicitly says the statute is binding on the state. That's not too bad. On the ratio of the South African judgment, I mean, this is a difficult question, and I guess in effect we have two questions along the same lines. It's a difficult judgment to read, but my interpretation of it, and obviously I'm not a South African lawyer, is that in effect the judges, all of them, ultimately base the lack of immunity on Section 4.2 of the Implementation Act, and they in effect say that the effect of Section 4.2 is that there is no immunity for heads of states. I think they're saying this even in cases where South Africa seeks to prosecute a person, a head of state within the country. Now, if that is correct, I think that's a very far-reaching ratio. I think that would suggest that even in non-ICC cases, there is no immunity, because Section 4.2 does not apply only in cases where the ICC has issued an arrest warrant. I think that is clearly correct, that Section 4.2 does not apply only then.
Okay. Thank you. Max?
Very quickly, if I can pick up again just on some of the points, but I mean, Navi's point was very interesting about the United States pushback against the International Criminal Court, and Navi's right to highlight how there was the American Service Members Protection Act passed by Congress, which said that you're going to send any United States peacekeepers to The Hague, and it was called the Rescue Them from The Hague provision, or whatever it was. They'd actually be parachuted out. And there was a threat, and the important point is there was a threat by the United States to a number of other states that if they signed up to the Rome Statute or didn't sign up to these particular immunity or impunity clauses, as they were called, then they'd have a backlash in the form of their military aid being suspended. Interestingly, at the time that threat was made to South Africa, it seems like another country altogether, South Africa resisted that very fiercely and said, fine, scrap our military aid that you're going to send to us. We're members of the Rome Statute, very firmly so. And it goes to the next point, Tladi, you're making about how, I think your lesson you rightly draw from this case is that be careful if you're going to invite somebody. And there again, it's an interesting change in the South African position, because up until this conference, South Africa's position was known as the South African position, which is you tell the people that you would otherwise have difficulties with if they came to AU conferences or other events. Look, this is a difficulty for us. Please don't come. So we may invite you, but we actually don't want you to accept the invitation. As protocol, we'll send you the invitation, but by back channel, we'll let you know we might have to arrest you if you do arrive. And that was the position in respect of al-Bashir previously. Our government's position firmly in respect of the attendance at President Zuma's inauguration and at the World Cup and others was a robust position, which was to say, we have our obligation under the Rome Statute, and if you come here, we will arrest you. What happened to the immunity debate? There's no question of, well, we won't need to arrest you because you've got immunity. The message was clear, we will arrest you. So something odd happened somewhere politically to change the South African government's position. And some have suggested that what happened was that there was, either recklessly or by design, there was a decision taken to set up a clash between norms, regional and international. And that South Africa would be the venue for this to play out, sadly. But now, as I say, right or wrong, we'll see where the Constitutional Court, if it goes there, eventually comes out in this. There is a court saying, you did the wrong thing. Very last point, sorry, very quickly. It's just, Charles, around the state practice and how that might ultimately, if I understand you correctly, your suggestion is that might, in fact, support the immunity protocol, the Malabo protocol, and the provision Article 46. I think there are a number of reasons why that's wrong, but I think the problem is that might have been put to the African Union and its legal advisors had they only invited civil society participation in relation to that very debate. Unfortunately, that was closed down, so that opportunity was lost.
Okay, thank you very much. Chris, do you want to respond?
Yeah, so I'm going to be schizophrenic and put on my positivist hat and then say something critical finally. So the first point is this idea of the distinction between an effective construction and a teleological construction. Right? So an effective construction of a statute is to stop the statute from being rendered absurd by implication. A teleological interpretation is to say, this is the purpose of the statute, we're going to aim in that direction. Right? People conflate those two when they think about 27 and 98. So the argument for a teleological interpretation says, well, 27 removes immunity, evil people are evil, we should pursue this at all costs, and so we should abandon immunity through 27. An effective construction would have to show that but for that interpretation it would be absurd. And I think that's an absurdity for a simple reason. There's one president who's appeared before the ICC so far, and he didn't appear by way of arrest. So the only president who's ever appeared before the ICC appeared by operation of Article 27 and not 98 in any way. Right? So the only example we have is when 27 operates independent. So you can't say that you have to read them together in every circumstance because we have one example and they haven't been read together. So that's my response to perhaps the redundancy idea. Two critical points about arguments, and I'm making these with a disinterested interest in terms of civil society's defenses to some of these allegations. The first is this idea that Africa signed up to the Rome Statute and therefore they should live with those consequences. That is an incredibly thin argument, because what happens when Africa pulls out is that you don't have a response. You need to have a better argument than, well, you signed up so you've got to live with the consequences, because that is like a revolving door. There's temporary consequences, but long term you're going to win the battle and lose the war, right? You have to have a better argument. Related to that, this idea of spoiler, it's remarkable to me that African states are positioned as spoilers. Imagine a state that doesn't sign up to the Rome Statute, that goes out of its way to prevent other states from signing, and then arrogates itself the right to assign states to that statute. That's a spoiler, right? It's not really fair to say to African states, well, haha, you signed, look, you look embarrassing, you're stuck in this kind of camp. I don't think that's the right way, because it discourages signing. What you're saying to the rest of Africa is don't sign, because these guys did, and they're in all kinds of trouble. So the state consent argument for the Security Council, I think, needs to be rethought. The second, or the final argument, is the African court argument. The high watermark of this argument, and it comes across again and again, is resources. Right, so yesterday we discussed how the African court has a better list of crimes than the ICC because it includes transnational crimes. The African court has corporate responsibility, which we understand to be a good thing when you're talking about the political economy of international crimes. The reason that people come up with most foremost is, well, it won't work, you can't fund it. That is, with respect, it's a argument of incredible poverty, if you excuse the pun. Because what you're saying is that whoever can afford to do this can do this. Right? You're saying that international criminal law ultimately rests on who can pay the bills. And I think as civil society, you should be wary of that kind of argument. There must be a better argument than saying, well, Africa, it's a great idea, but you can't afford it, so now we're going to stick with the ICC. I think that's a particular argument people need to think about perhaps in more detail.
Okay, excellent. Thank you very much. Dire, you have exactly 30 seconds
That's
to
not
respond.
absolutely not fair.
Yeah, no, but please try to be brief.
I will speak. The question that Attilia raised made me think of a question that was asked by Femi earlier, which wasn't responded to, and that related to the immunity of heads of state under their own constitutions. But I think the immunity that we're talking about, the immunity under international law, is not immunity of a head of state before their own state, right? So that's not an international law rule. It's always an immunity of a head of state before the states of other courts. I think that's an important point to make. And then Max, with respect to your question or your comment about the spoiler, I mean, I think you're right, there is a legal framework and you have to accept the consequences, but that legal framework also contains an Article 127, and so in looking at sort of the broad thing and the consequences, that's also part of the legal framework, and you cannot ignore the legal framework, which is, well, this is not how we thought this institution or this treaty would be interpreted, but since it is being interpreted this way, and this is not what we really signed up to, we will then exercise a right that we have in terms of that very same legal framework to chart a different course. And I think that's also a point that you have to take into account. I mean, I guess on the question of Article 27 and its scope, does it apply to heads of non-state parties? I am more pro-ICC than the ICC itself, and I'm more pro-ICC than the church itself, it seems, because I think it should apply to non-state parties. And the argument that Dapo makes about, well, what if two states together? I think we have to be a little bit realistic. In those two situations, I think it will be very clear that those states have control over the court. No one has control over the ICC, and so no one can say the ICC is therefore being used as an instrument to prosecute the head of a state by one or two or three states. It's an institution over which, theoretically, no one has any control over, and so you cannot take the control back to a particular state and say it's a way of circumventing the customary international law rules. And so I'm not really sold on that. My final comment is based on what Charles said with respect to the question about the interpretation of the resolution and whether or not the Council ought not to be clear about what it's doing. In fact, if you look at the resolution, referring the situation of Sudan and also the situation in Libya, it's quite clear that the court does not interpret its power, the Council does not interpret its powers as being able to place a state in the position of a state party. That's quite clear. It's quite clear because if the Council thought that what it was doing was placing Sudan in the position of a state party, it would not have felt the need to say Sudan is obliged, because Sudan would be obliged by operation of at resolution. The fact that the Council goes as far as to say Sudan is obliged to cooperate is an indication that the Council itself does not assume this overwhelming power that everybody else wants to give it. Thank you.
Okay, excellent. Thank you very much. I'm afraid we've run out of time, but we can continue this debate, of course, during the coffee break and half an hour. And before we break, please join me in thanking the panelists.